34. Due to personal reason, the matter is released from the list of this court. Liberty to mention before the honorable court in law. Yes.
Item 1, Mr. Anand, this one is appealing. His wife and son both are not there, he's in liable. He requested me, let it be kept as item number 1 on Monday. I will inform him to come on argument. I have to be responding.
Mr. Arul Prashant, learned advocate appearing for the submits that the learned advocate appearing for the appellant is having some personal difficulties and the prays for fixing the matter on
Monday.
7th of August 2025. Let the matter appear on 7th of August on the 7th July. Sorry, 7th July under the same heading.
Okay.
Next.
I appeal for the petition.
Yes.
There is an application under section 483 of BLSS. The case has already been charged sheeted, my lord.
So who is appearing for this? Notice issued.
The mother is appearing is on the leg before court pass over.
Pass over.
Good luck.
For the petitioner.
Yes.
I can find you. It's true that there is a delay. And in his filing an application for the all of the witnesses to produce documents. But the court ought to have looked into the fact that these documents are nothing but notifications of the government authorities. I wanted to produce those documents. The court has rejected the application basically on the ground of delay. Those notifications are notifications relating to section 4 and details are on page number 9, your lordship.
Yes.
These are the documents, your lordship. The additional document that I have to file notification number this, date and this, all notifications of the government I wanted to file, your lordship. This is no personal documents I wanted to produce before that.
So why you want to recall? You can summon the witness bringing the document.
At the stage of argument.
Might be.
These are all original documents are there.
Might be, but recall. Let me. If you want
the
to.
court is completely closed this stage. I want to produce these documents. I have to summon the authorities.
Correct.
Yes,
So recalling after the 12 years. 12 years.
Sir, I will get it.
So appearing for the petitioner. Then appears on behalf of the opposite party. The petitioner has filed the affidavit of service. Let the same be kept with the report. The petitioner has filed the present revisional application. Being agreed and is satisfied with the order filed by the district judge in LA case number 1/4 of 2021 dated 2nd April 2025, wherein the learned judge has rejected the application filed by the petitioner for recalling of PW2, PW1. PW2 for production of document. The counsel for the petitioner has brought the attention of this court to the application filed by the petitioner before the learned district judge on 30th September 2024 under order 8-17 of the CPC, wherein the petitioner intend to bring some additional document, that is the notification and the notices issued by the administration. Fullest. Consider the submission made by the counsel for the petitioner for use and the application filed by the petitioner. This could find that that there is no illegality in the order passed by the learned district judge. Accordingly, this court is not inclined to interfere with the impugn order, but however, the petitioner has liberty to take appropriate steps for bringing the said documents in early case number 4 of 2021 by issuing summon upon the authorities who are in possession of the said documents. In view of the above, CO number so and so for this. Why? Who is appearing? Huh? Anjina was here. Paso.
I know the respondent status.
Yes.
Revision, again, conviction and appeal. I will show your lordship, there are 7 points. The first point I show your lordship will see that and remand it back.
Remanded back.
Not- But the other 6 points, your lordship will then wonder, is there any point in remanding it back? Kindly see the one page I am pointing out, 133.
409.
Yes. 409, 468, 471. Why not just leave page 133?
Page
133. 133 and 134. Beyond that, I don't need to argue on the point of remand. Total of 21 witnesses. 19 circumstances derived.
Where is the judge? Where is the judgment?
Now, so far as the trial court order is concerned, we will gather at page 144.
And he relied upon all documents and all witnesses.
The demand is clear, but my point is, if I can make out a case that the evidence itself does not justify a conviction or even a finding that there is a need to remand back, then my court may consider that the judgment itself is bad in law. There is no point in remanding it back on the evidence that is available and thereafter proceed. So if that can be done, then I can address your lordship on the merit.
Yes, Mr. Kamaka, you are satisfied with the 313?
313 lordship, that paragraph has been mentioned, lordship.
What?
Paragraph. You have to put each and every circumstance.
What paragraph you mentioned? You judgment, you have relied upon all the evidence, PW1, PW2, PW3, all. Finally come to the page 153 onwards. All witnesses have been examined, you have relied upon, and come to the documents also, all documents have been examined. So where is the question on that?
I think that question not, that is missing, but defense, was given an opportunity to whether you could be.
That is different thing. In the 313, the accused must know what is the evidence and what is evidence going against him and what. So he has to explain.
Paragraph second, listen, behind this, lordship.
Yes.
Listen, what was the before the court that you have manufactured and fabricated false document in the name of others among whom someone dead. At that point of time, and by fabricating the document, you have misappropriated the government money in digging a pond in the name of those innocent.
What document? What document?
That is, it is matter of it. I cannot go beyond that.
Let it go back.
Merits on your
Because of this 313, how the merits come.
My lord is also well done. It is there that there is no point in remanding if the prima facie evidence does not make out a case. I'll just tell you lordship very briefly, I won't waste time. the prosecution very funnily has three contrary cases. The first case is de facto says, my father was not working in the pot digging, he died. But
He was
money
admitted, subsequent died, but criminal disease.
But money was disbursed to him.
Correct.
Second prosecution case is, money was never disbursed to him. Money was returned back to the government, which runs directly contradictory to the case of the company. Prosecution case itself is that money was supposed to be disbursed, but he died. Therefore, the money could not be given to him. It was submitted in government account by channel. So the two cases can't go together.
Committed and returned back to the government.
Returned back. That's the prosecution case.
Not utilized by the accused.
So complainant says false signature and money was taken
That is with regard to the father.
to the father.
What about the other three?
Now that's the third point. The third part of the case is that there are several people who come and say, we never worked there, we never took money there. But the money that was actually spent on that and was actually disbursed has been spent. Now there are two parts to the misappropriation. The first part is they are saying that the person who has died, the Pradhan, he used to identify that these will be the workers, these are the person. I'm not a local person from there, I don't know them. So Panchayat Pradhan and PRA members used to come there. They will say that today these so many people will work. I used to write down the name. Thereafter, those people used to work and go. When the work was completed, those people used to come. I used to give them the money, they used to sign. Now, whether those persons were actually the workers or some other person's name was used, this cannot be attributed to me. The reason being, if you go by the conclusion of the trial court and the appellate court, the signatures are not of these witnesses. But that's only half the story. The second part of the story must be that those signatures are mine. So the court is coming to the conclusion that because the expert says that those signatures are not of the witnesses, therefore you stole the money. In order to show
So there is
that-
no document seized by the police authority or produced and during the trial, this amount utilized by you.
the amount.
There is any evidence on
There
that?
are two documents. One document is a master roll, which has a list of people,
That is
and one has acquittance,
correct.
where they have come, they have taken the money, and the signature is there.
Correct.
Now the expert says PWs 8, 9, 10, 12, 13, 14, who are saying this is not our signature, it is not their signature. But he's not saying it is my signature.
Correct. It is
So-
not their signature. They have not worked.
They are
It is not their signature.
Now,
And they have not received money.
my job is to stand there. Pradhan will identify this is A. He has worked so many days. I will say, okay, you work so many days, take your money, you sign the paper. Yes, I. This process has been done, admittedly. Money did not go in my pocket. Then where is the misappropriation? My point is this. My job is to disburse money and take signatures. It's not my job to verify identification with Aadhaar or whatever document. It's not my job. That is the job of the Panchayat Pradhan.
Yes.
Admittedly, Panchayat Pradhan did that job. Who was identified to me as ABC? I gave the money ABC. He has signed. I don't know personally. I have no knowledge who is that person. I'm not a local person of that person. Now, in that situation, the expert says these are not the signatures of the witnesses. Witnesses says we never worked, we never signed. So the Panchayat Pradhan has to explain who he has identified as who. He faced the trial, he died during trial. And in fact, in the appellate court order, the specific order is recorded that he has passed away. So that is why it has abated. So now the problem is the person who was key to the identification,
He was not there.
he was not there. Now, so far I am concerned, how court can say because the signature is not that of the witness, therefore you have misappropriated. There must be something more.
You explain in the 330.
Remanding back on the due to
On the stage of 313.
Plus.
313 and full.
And I will not go to the merit of.
Stage of 313. Naturally.
Will say that we have already argued also.
So only 313, then the judgment will remain.
One difficulty is that the service has been completed, but they are not appearing.
Who?
And I don't think
Who?
defect of complaint. They
necessary.
have served it by force, I filed the affidavit of service, but they're not appealed.
Where is
Unless
that?
the lordship wants through the SHO letter.
Yeah, that will be better. That will be better.
Because in his presence, it should be remanded. Later, if they challenge it that in our absence without hearing us, it was remanded.
It is, where is the track report?
My lord, I have annexed it.
Address it, deliver.
It says on the
Which-
first one, delivered, Pishad Nala.
Who is the complainant?
Opposite party number 2. Sanjay Misri.
Record an order. Sense opening for the petitioner, sense opening for the respondent. The petitioner has filed the affidavit of service showing that the notice of the case has been served upon the opposite party number 2, but none appears on behalf of the opposite party. Let the affidavit of service be kept with the record. The petitioner is directed to serve one extra copy of the application along with the annexes to the non-advocate appearing for the estate, and the estate is directed to serve the notice upon the opposite party number 2 through the concerned police station, and to file the report before this court on on 8th of June, 8th of July 2020. Let the matter appear under the same heading on 8th July. 8th July. Please.
No, make a deal for that, so anything.
After the order, the counsel for the petition already saw the London counsel for the state in the open court. Next.
Lordship, in item number 6, Your Lordship, I'm appearing for the respondents, Your Lordship. I'm seeking for extension of time to file our opposition in this matter, Your Lordship.
Give. Who is for the petitioner?
Hmm.
10th June, there is a direction upon the respondent within 2 weeks with the
Yes,
advance.
Your Lordship. Your Lordship, I need 1 week's more time to file the counter affidavit, Your Lordship.
None appears on behalf of the petitioner. Counsel for the respondents press for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Place the matter before the next available circuit.
Deeply obliged, Your Lordship.
I appear for the divisionist hearing.
Yes.
And for the responding lordship states.
The LCR was called for the division.
Here I am. Yes. Where is the impending order?
The order is dated 19th of March 2025, which is the next at page number 85. This is the judgment passed by the London Session Judge, whereby the order of conviction passed by the London Trial Court, which appears at page number 64, was the
That's 279, 338.
279, 338.
That is 3 by 8.
Of 181 of MBA.
Hmm.
Now, the London Trial Court has passed an order of conviction, and thereafter, trial court has left me on admonition for a period of admonition. They have
Admonition.
admonition under section 3. There was people is on probation, then certain period
Right.
of respect. Since it was on admonition. And thereafter, I was also directed to pay a compensation of rupees 4,000. In addition to that, I was also directed to pay a
4,000 to the PW9 victim.
Yes, a cost of rupees 4,000, and to the victim it was rupees 1,000. I challenged this particular order before the London Session. London Session Judge affirmed this case. Challenging that order, I have prepared a revision application. Here for this.
Yes.
Lord, may first kindly come to the FIR concerned, the FIR was chalked out on, I'll just narrate the brief facts. The brief facts is that the complainant happens to be a driver of a truck, a water tanker, who had taken water from Machi line and he was proceeding towards Makapad. The moment he crossed Hotel Sinclair, he found that a car which was going in front of his vehicle suddenly stopped. As the result of which, the driver also stopped his vehicle. And he found that two persons was coming from the opposite side. They saw that the car suddenly stopped. See, when they applied brake, they skid and they have dashed into the car. And the two-wheeler. The person was riding the two-wheeler. Based on which, the person who was riding the car, he has informed the PCR. The PCR came and they had taken these two victims who were there on the two-wheeler to the hospital, and then the treatment got done. Now, my lord, kindly see, the affair was chalked out on the basis of so-called statement of the complainant who happens to be the truck driver. Now, kindly come to the front page, which is at page number 55. It starts from page number the affair, it is affair, and it ends at page number 55. I am just intending to point out the left portion of the same where there is written as note. It was recorded at Makkapad at Mazarpad, sorry. It was recorded at Seashore Road on the date of at about 11:40 hours. This may kindly be taken into record.
Yes.
Now, Lord, may kindly come to the evidence of PW1.
Yes.
The
So
evidence
this-
of PW1.
Sadakat Ali is the complainant.
Yes, he is the complainant. My lord, his evidence starts at page number 60.
Yes.
Lord, without wasting much of time, I would just like Lord to kindly come to the last 5 lines of the examination in chief of the PW2 who happens to be the complainant. It is at page number 1616. Now, the driver of the car called PCR, police came, and we all took the rider of the scooty and the pillion rider to GBPath hospital for treatment. Thereafter, I attended the duty. At night, I came back to PS on being called by the police. Police recorded my statement at PS on the basis of which the present case was initiated. That is on the fateful day of 7th June 2016. In the night after he has attended his duty, he was called to the police station. And thereafter his statement was recorded, based on which an affair was chalked out. Now, my lord, may kindly again come to page number 55.
Yes.
My lord comes to page number 55. The timings of the affair, as per them, it has been noted as 14:10 hours. 11:40 hours.
Yes.
11:40 hours means it is in the morning time and it is at Mazar Pahad.
Correct.
Whereas this witness goes to show that his statement was recorded at the police station in the night hours when he has completed his job and then he was called to the police station. That means the affair, the basis on which the investigation started, that itself becomes doubtful. As per his version, the statement was recorded at the police station. As per the Fadbear, it was recorded at the PU.
Yes.
This is the first point of contradiction here. Now, my lord, may kindly come to the injury report, my lord.
Yes.
Injury report is at page number 59, my lord.
Yes.
Now, my lord, kindly come to the history that was written by the doctor, because doctor was not the person who has seen the incident, but definitely doctor has written a history of the occurrence on the basis of the versions so-called given by the either the patient or the particular person. Now, kindly see, my lord. The patient was brought by the police. Patient was hit by a four-wheeler while riding a pillion rider. That means there is a contradiction. This itself goes to show, because the doctor was not an interested witness in this case.
Yes.
To save the victim of this particular case, that is the rider of the two-wheeler. Neither the doctor can write the history of his own.
he will have to reflect the history on the basis of either the statement of the police officers or by the other persons.
Where is the examination of the doctor?
Yes,
Was
sir, I'm
examined?
coming to. No, it starts at page number 29, PW8. Will you kindly come to the evidence?
Yes.
Presently, I am posted at Additional Medical Superintendent, GB Pant Hospital. On 7/6/2016, I was a medical officer at the same place. On the said date, I was on duty at casualty. One injured person, namely Shubham Kumar, was brought to the police, brought
by
me
police.
by police in connection with a road traffic accident. As per information, I
Recorded the history.
Recorded the history of head injury due to hit by a car when the injured person was riding a motorcycle as a pillion rider. The doctor is not an interested witness. The patient was semi-conscious at the time of examination. I found one hematoma on the posture. These are all the injuries what the doctors have found.
Okay.
And it was the cross-examination by the learned counsel, Sri Arkanadi, it was declined.
Yes.
Now, my lord may kindly come to the evidence of PW1. He's a former witness, Lord.
Yes.
He has received the information that there was an accident that took place. He rushed there and he says that he has recorded the statement of the Sadakat Ali, where he has recorded the statement of the Sadakat Ali at the place of occurrence. Whereas the person whose statement was recorded, he himself says that his statement was recorded at the police station.
Yes.
The most important thing over here is the accused person here is not an FIR named accused. It has only been written that the rider of a two-wheeler, kindly come to the FIR, his name does not appear. Rider of two-wheeler, so and so, so and so.
Correct.
It was the bounden duty of the prosecution to first establish a fact, rather because the two-wheeler rider as well as the pillion rider was a stranger to the complainant as well as the truck driver. They were not having any prior acquaintance. So when there is an ambiguity in not defining the name, then in that event, it was the duty of the prosecution to call the so-called witnesses, including the complainant, to come and identify. They should have conducted a TI parade for identifying a person who was the actual rider of the particular motor, which the prosecution has blatantly failed to do it.
But for the other witness are not identified.
No, not even a single witness other than the pillion rider.
Yes, who is the pillion rider? Who is the pillion rider?
His friend who was deposed against him.
Where is that?
Lord will kindly come to. He was the last witness to have been examined.
PW9. Shubham Kumar.
Yes, Lord.
Page 31.
Yes, Lord. Lord, on the day of the fateful, means on the day when the accident took place, the person who was initially riding the two-wheeler was a minor. There was no case initiated against the parents for having given the two-wheeler to the minor. This is one thing. Now,
So the two-wheeler belongs to whom?
Two-wheeler belongs to the parents of the person who was initially driving. That is the
PW9. PW9.
Yes.
The Michael belongs to the family of
Family of
mother of PW9.
Yes.
Correct.
Lord, kindly come. Earlier, my family was a resident of Prem Nagar. On 7/6/2016, I was at Prem Nagar. On that day, between 10 to 11 a.m., I was going from Jangli Ghat towards head post office on my scooty. That means he said that he was
He
right.
was riding.
On the way, I met Munawar Hussain, who is the accused herein, with whom I had a prior acquaintance, and I allowed a lift to him on my vehicle. That means still he was found driving. Thereafter, we reached the post office. From post office, it was stated that they require 15 minutes to deliver my article. So, I along with Munawar Hussain decided to go to Gymkhana ground, which is located nearby. After reaching Gymkhana, on being asked by Munawar Hussain, I allowed him to drive the scooty. After having control over my scooty, Munawar Hussain started driving the same in a rash and negligent manner. I repeatedly asked him to abstain from such driving, but he did not pay any heed to me. In the meantime, while we reached Hotel Centralis locality, the scooty fell down due to rash and negligent driving, and after such fall, I lost my consciousness. I gained my consciousness and discovered myself lying at Apollo Hospital, Chennai. I was undergoing treatment at Apollo Hospital, Chennai. In consequence of such incident, I lost my memory, so I cannot say the exact date on which I was admitted in the hospital and the date on which I was discharged. I gradually regained consciousness. I came to know from my parents that I went treatment at Apollo Hospital. Now, my lord, may kindly come to the cross-examination of this question. In the year 2016, I was a student of class 12, and at that time, I was 16 years old. The scooty in question was registered in the name of my mother.
Yes.
I have the knowledge of riding a scooty that one need to have license from the concerned department of government. At that time, I was holding a learner's license. Police did not seize the learner's license either from myself or my family. That means there is no question of having any learning license. The Chandigarh Radhakrishna Mandir, from where I have gave a lift to Munawar, is 5 minutes away from my house on the scooty. From Chandigarh Radhakrishna Mandir to head post office, it takes about 7 minutes. It took 10 minutes for reaching Gymkhana ground from the head post office. It is the fact that we reached Gymkhana grounds via girls' school, so and so, so and so. It is the fact that there is a speed breaker. So it is the fact that during morning hours at around 10 a.m., there remains more than usual traffic activities on the said roads. I cannot say whether near girls' school there is a traffic posting. It is a fact that on my way to Gymkhana to Hotel Centralis is having number of road turnings. These may not be so very important, but there is one particular line, my lord, I would like to draw the attention of this honorable court. After that, it is the fact that I have not stated in my statement before the police that after the incident I was taken to Jeepat Hospital. Now kindly see, it is the fact that police never obtained my signature in any form or document. Now, he has said that his statement
Mr. Ilongo, but
Yes, sir.
this PW9 has identified you, correct?
that he was
He has identified you. He is his vehicle used by the accused, and he was the pillion rider. When he was the pillion rider, the accident was over.
Hello.
And he has stated that he was driving thus a negligent manner. Hussein started driving the same in Russell negligent. I repeated asking him to abstain from such driving, but he did not pay any heed to me. What is your reply to this question?
Kindly see his evidence or his version before the court will only be reliable if his statement under section 161 is recorded. If he has not made any statement to the police officers, kindly see when he was admitted, when he was discharged, and he does not say anywhere that he has given any statement to the officers concerned at any point of time, nor he has stated that he was interrogated by the police.
No. He has stated that it is a fact that I have not stated in my statement before the police that after the incident I was taken to Jeepat Hospital. So in cross-examination, if you take otherwise, he
After that, there is one more line.
It
Kindly bear me for a moment. It is the fact that after my discharge from the hospital, after undergoing prolonged treatment, police has never recorded my statement.
correct.
If that be the position, if his statement was, because he said, as per his version, he has lost his consciousness.
Hmm.
He regained his consciousness when at Apollo Hospital after a period of a considerable days of more than 20 days.
Correct.
And he is also admitting that his statement was never recorded by the police after he got discharged.
Hmm.
And if his statement was never recorded,
Hmm.
then how far his statement can be relied upon at the time of evidence? This is to be seen.
Yes. Yes.
Lord, apart from this particular witness, who happens to be his own friend, Lord will be surprised as to what made me to come to a revision application for this small petty case wherein the particular accused was left out, admonition. Lord, my basic reason is that, Lord, kindly see, there is not even a single witness who has identified and said, yes, I can identify this person, even during the course of evidence, because there were some times wherein the witnesses come and said, I can identify, but because the accused is absent by filing 317 applications, so I cannot. But they have not given any description. Not, was it not because when there is a confusion with regard to the fact that whether the person slipped down and then got struck with a car, and then there is a confusion that the car came and dashed, and then there is the confusion when the place of recording of evidence itself is doubtful, then the entire things will have to be scanned, and then it has to be seen whose version is correct.
No. That's all. Come after 2. At 2. Come at 2:20. Huh? 2:15. Come at 2:15. Yes.
But if the FIR itself becomes doubtful, then before registration of FIR, whatever proceedings was done, that becomes inadmissible. Now, if we rely by the evidence of witness two, who has stated that it is 9 hours, the statement was recorded and then the proceedings were initiated. Then let us come to the seizure memo of the 2 million. The seizure memo is there at page number 48. Lord, if we come to page number 48, which reflects that the two-wheeler which went into an accident was seized at 13:20 hour. Then such event, we will have to presume that such seizure was done prior to the registration of the affair. If we go by the evidence of the PW2, who has said that his evidence for which his statement was recorded at the 9 hours. Now, the seizure goes. Apart from this, there are two witnesses to the seizure. One is Mr. Srinivasan and second one is Mr. Mohammed Ismail. I will not kindly come to the evidence of the seizure witness. One is Srinivasan, who happens to be the driver of the car with whom the two-wheeler allegedly got dashed. Its evidence is that page number coming back. Kindly here. Yes, sir. Kindly come to page number 20. His evidence is at page number 20. He was PW4.
Yes.
Lord, may kindly come to the cross-examination portion because he has narrated the pattern of incident without narrating the name of the rider of the motorcycle. Kindly come to page number 21. That is page number 21. At the time of accident, there were other moving vehicles and pedestrians on the road. I did not disclose the name of the scooty rider to the police as I did not know. Now, Lord, kindly come to the third last line. It is the fact that I signed the detention memo and the seizure is at the PS. Now, kindly see, again, kindly come to the page number 48, that is usually which says that it was seized and the place of seizure is at Seashore Road near Mazar Pahad. He has put his signature at the police station. That means his version goes.
Yes.
His version goes, Milord. Now kindly come to the evidence of the second seizure witness, that is Mohammed Ismail. His deposition is at page number 23 and he is PW 5, Milord.
Yes.
Milord, the very first line of his cross-examination, he has stated that he has not given any statement to the police. And if he has not given any statement to the police, then in that event, whatever he has stated in the examination in chief cannot be relied upon.
But he stated that I signed the seizure list in the Mazar
Yes, he
Pahad.
has signed the seizure list in the Mazar Pahad, but whether his statement should have been recorded by the IO during the course of investigation or not, the reason is that here the IO was never examined in this case. Only the SHO has come and he has deposed the acts of the IO concerned. The reason for examining the SHO and not examining the IO is that, unfortunately, by that time, the IO of this case expired, Shri SI Jawahar Singh. So,
Yes.
kindly come to the cross-examination, page number 35. So, according to him, he is only the charge sheeting officer. Kindly come to cross-examination portion, first and second line. I have no knowledge whether the site plan was prepared at the police station or not. Not if either he will have to deny it or he will have to say it. But if he says that he doesn't have any knowledge, then it can be presumed in either way.
Yes.
It can also be presumed that yes, it might have been prepared in the police station.
Yes.
No, my lord, the doctor has examined the so-called victim, that is the pillion rider, immediately when he was shifted from the PO by the PCR. Now, admittedly, if we go by the evidence of PW2, whose statement was recorded in the night, then it is quite obvious that the injury report, which has been cited at page number 59 and marked as PW8, should not contain the FIR number. Lord, kindly see page number 59. The doctor has examined the patient prior to recording registration of the FIR. But here the FIR contains the FIR number. Lord, summing up my arguments would be in this fashion, Lord. The FIR is not reliable. The only eyewitness of this incident was the pillion rider, who was the best person to say. He has stated that the statement was never recorded. The fact of seizure becomes doubtful, and the very fact that the accident took place on account of being dashed by a car or the two-wheeler will have a conclusion when we examine the evidence of the doctor who has said that the car has gone and dashed the two-wheeler. So these are the facts and circumstances which creates doubts, and which the learned session judge as well as the learned trial court has not given weightage to, and they have convicted.
Where is the site plan?
The site plan, the site plan is at page number 63, my lord.
Yes.
Lord, the site plan also contains the FIR number. The site plan also denotes that there are vehicles lying there.
Oh, Sinclair's Hotels, where is?
They have not shown the Sinclair's hotel in the site plan, sir.
No, the place of occurrence which they have shown.
Yes,
A. A. A
is the Seashore Road.
Seashore Road, no,
Yes.
Seashore side. Seashore side. And they are coming from Mazar or they are going from Mazar?
No, but they were found coming from Mazar Park.
Coming from
Towards-
Mazar part.
Bazaar.
Towards Bazar.
And the offending car was going from Sinclair's towards Bazaar,
Sinclair's towards Mazar.
to the Bazaar.
Sinclair's. Yes.
These are my arguments.
Yes.
First man. Sir, kindly come to the page number 59 actually.
You
point was
first you satisfy me.
Yes.
Come to the page 63 in the site plan.
63 lots.
Yes. Sixty-three is the site plan. Correct?
Correct, sir.
So the vehicle is coming from Mazar towards Sinclair's Hotel, and the car going towards Mazar from Sinclair's Hotel. Correct?
First.
And this shows that the car was on his side, and the scooty dashed in front of the car. From the scooty side, also showing the skid mark
Right side.
from the right to left. Now come to the car side. Again, the car is also showing the skid mark.
First.
So both vehicles are skid and dashed.
First, car speed mark 330 mk.
330 mk
Yeah.
meters, MTRs.
Yeah. Meter And scooty also.
11 meter, 1.1 meter, 1.1, no, 11 meter.
Yeah.
From where he has taken the 11 meter, I don't know. 11 meter, I don't know. I didn't find any road in 11 meter in Andaman.
Yes, sir. But scooty showing just right side of the.
Hmm.
Scooty
Correct.
showing right side.
That's why I am telling your car was on the way. Your car was on your left side because car is going towards from Sinclair's towards Mazar. It is on the side of the footpath. There's no difficulty. And the scooty went on the wrong side and dashed against the car in front of the car.
Sir.
No problem. But if it is so scooty, they are also showing the skid mark and the car also showing the skid mark.
But who is the best person? Who sustained injury? Who is the best person? The car driver also examined. I will come to the deposition of that driver that who has seen the accident.
Okay.
Who has seen the and
Okay.
who is the best person? I was not there, nobody is there except one eyewitness, the driver of the car, and this victim.
Correct.
And the victim was driving that. Who was driving his scooty? Scooty was driving by his scooty, his friend. So what enmity? What was actually happened is stated before this.
Okay.
What was happened? Then come to the
Sure.
that page number injury report. First point raised by my learned friend that regarding the history,
59.
59.
Yes.
Regarding the history, firstly, doctor's duty was to examine the patient to sustain injury. Immediately, he rushed to the hospital. He judged immediate treatment. His duty only to examine. He examined. Kindly see that the learned friend has pointed out patient brought by police. Patient was hit by force. By four-wheeler while riding as a pillion rider. But doctor is the not best person at the.
So where is the injury report of the accused?
And
For the accused was not probably harm. That is the reason FCR has come.
Okay.
I know. Then whether this part history that what was actually happened on the spot, it was who disclosed to the doctor. Nothing is in the injury. Who disclosed? The duty of the doctor only to examine the patient. Then issue an injury report. What type of injury has been simple or grave? He has issued. So this contradiction, that history and with that part, the history, that is contradictory statement that cannot be taken. That cannot be taken as evidence. The history part.
Okay, history part will not be taken. Then you have taken that evidence on your evidence of the evidence of the doctor. Kindly come to the evidence of the doctor. Kindly come to the evidence of the doctor. Page 29.
May I read first?
Yes.
Presently, I posted an additional medical superintendent, Jimipon Hospital on 7 June 2016. I was a medical officer at same place. On the said date, I was on duty at casualty. On injured person named Suman Kumar was brought to me by police in connection with a road traffic accident.
Correct.
As per information, proceed. As per information, what is the history of head injury due to a hit by a car? Right. I again repeat, that who has disclosed it? Because I already stated that duty of the doctor to examine the patient to give injury report regarding simple or grave. Regarding information, history of the assault, how it was happened, totally irrelevant. Totally irrelevant.
So you mean to say whatever the evidence is recorded by the magistrate before the court on oath, that is irrelevant.
No,
Then
see, that is not relevant.
so why your APP was silent when why your APP has not taken the clarification of this statement?
See, I already stated that doctor being a given
I am not a doctor. Your PP is the law-knowing person. He is conducting the prosecution. She knows what is the case before opening up the evidence. She knows if it has been done in the injury report and the doctor has stated that. So why in your public prosecutor has not taken the clarification on that statement? So what is the before the court on record on oath that has to be taken as a correct, true and correct. So we cannot interpret the statement of the witness in our way. Court cannot interpret the statement which is available on record on oath.
Lordship,
Then
because it is evidence.
evidence,
Before the court.
and that is corroborative with the documentary evidence.
Lordship, that I already submitted that first point regarding injury form, I already submitted. I will come to the deposition.
I am hearing, I am putting you this
Lordship.
question to yes.
Lordship. Then come to the evidence of PW9.
PW9. Yes.
Here it was. Earlier, my family was resident of Premnagar on 7th June 2016. I was at Premnagar on that day in between 10 to 11 am. I was going from Jamnagar towards State Post Office on my scooty. By Frank and Rayach on the way, I met Munawar Hussain, with whom I had previous acquaintance, and I allowed to lift to him on my vehicle. Thereafter, we reached the post office. From post office, it was stated that they require further 15 minutes to deliver my article. So I, along with Munawar Hussain, decided to go for
Gymkhana ground.
Gymkhana ground,
Yes.
which is located nearby. After reaching Gymkhana, on being asked by Munawar Hussain, I allowed him to drive the scooter. After having control over my scooty, Munawar Hussain started driving the same in rash and negligent manner. I repeatedly asked him to abstain from such driving, but he did not pay heed to me. In the meantime, while we reached Hotel Cynthia's local scooty fall down due to rash driving, and such fall, I lost my unconsciousness. I gained my consciousness and discovered myself lying at Apollo Hospital, Chennai. I was undergoing treatment at Apollo Hospital, Chennai. As a consequence of such incident, I lost my memory. So I cannot say the exact date on which I was admitted to the hospital and the date on which I was discharged from the hospital, and the period during which I underwent treatment. After gradually then unconscious, the last one I could have identified Munawar Hussain had to be present in the court room today. I can presently recall the number of the scooty. I cannot presently recall the number of the scooty. So the entire evidence of a person who sustained injury, that cannot be thrown out due to the minor contradiction. What was the minor? My respectful humble submission is that are a minor contradiction. We are human beings, Lordship. If I divorce after 5 to 4 years after investigation, copies of investigation, that defect of complainant's part, that my statement was recorded as PS about it. But the document showing that it was recorded as Majarpa. It is a contradictory statement as landed pen has pointed out. Firstly, documentary evidence is the best evidence. Oral evidence should be corroborated.
Documentary evidence.
Document is the best
Documentary evidence is to be proved by the oral evidence.
I submitted that part.
As per the law of evidence.
Here, kindly see, that is the minor, but it is a proof by the prosecution that yes, the statement was recorded. The question where it was recorded.
No, that is important, Mr. Kamako. See, if the case of the prosecution that immediately police has got the information regarding the incident, police went to the place of occurrence, and the person who was available, he has recorded the statement. On the basis of the statement, the FIR has been started.
Yes.
Case has been started, FIR is chalked out, case is started. This is simple case. But when the witness whose statement, the FIR is chalked out, it is telling that he has been called at 9 a.m. and his statement recorded at 9 p.m. and his statement was recorded at 9 p.m. So how you corroborate the documentary evidence with the oral evidence of the witness who has given the evidence on oath before the court?
Lordship, that is the very vital, that evidence before the court.
Correct.
The documentary evidence.
Correct.
The value of the deposition before the court is more than that documentary part. Lordship, regarding that part, I am admitting I cannot go beyond the record. It is an admitted position. I respectful submission is that on the basis of the statement, FIR chopped out, no denying in the cross examination that manipulation of the FIR have been chopped out. What are the duty of the officers after registration of the FIR? Investigation, charge sheet has been filed out. In that part, entire evidence came in the record. The prosecution has proved, yes, that driver was driving the scooty rash or negligent manner. Regarding that part, Lordship, after FIR, kindly see. Before FIR, that is a firm back. That is my respectful submission. That
Where is the evidence of Sadakat Ali?
Lordship, I am done. In number 16 laws.
Yes,
May I read first?
yes.
I am presently posted as a contractual worker at SPS unit. Hello. On 7th June 2016, I used to drive a water tank vehicle. On that day, in between 10:45 to 11 a.m., I was proceeding from Machiline towards Makappa via Shisho Road by driving water tanker vehicle bearing registration number such and such. When I reached the turning gear, Shankar Hotel, one car bearing registration number such and such, which was proceeding in front of my vehicle, suddenly stopped the car on the roadside, for which I had to stop my vehicle. At that time, two persons were coming from the opposite direction by riding on a scooty. The rider of the scooty suddenly lost control and the scooty along with the other rider, the pillion rider, dashed against the car and fell down on the ground and sustained injury. The driver of the car called PCR. Police came and we all took the rider of the scooty and the pillion rider to the GP hospital for treatment. Thereafter, I attended my duty at night. I came PS on being called by police. Police recorded my statement at PS on the basis of which the present case was initiated. That we are arguing that part that regarding first. This is the said statement bearing my. Then kindly come to cross examination. Cross examination is vital. Whether it was challenge any part regarding, it is of course a duty of the prosecution to prove the case beyond all reasonable doubt. But cross examination opportunity was given. Kindly see. I cannot say the name of the person who was riding the scooty. I did not disclose the name of the rider of the scooty in my front bear. Not the fact that I gave it as per the instruction of police. At present, I cannot recall the number of the scooty. Not that is the suggestion lordship at least.
What suggestion you want?
That contradictory that you yes, that contradictory cross examination.
Which is already on record. Why
It
the
is in the
why it is
record.
why it would come to the but he has stated that this is my on the basis of his statement case has been initiated. That statement is the Fardbaya.
Further.
Correct. But he is telling that 9 p.m.
9 p.m.
So what cross exam?
Place is PS Havari. It is, I already argued on that point, Lordship. That is a minor. We are human being.
Okay.
We are
Next.
human being. We are human being. He deposed before the court. Sometimes it can be. Then come to the regarding Caesar Lordship. That Caesar has gone. Lordship, can you see Caesar page number? 40. Hey, date of Caesar is 7 June 2016, Lordship. Timing is the 13:20, Lordship. Two-wheeler vehicle that was seized before Srinivasan, Muhammad Ismail. Caesar only proved. Date of offense only stated by everybody, Lordship. Timing of offense stated by everybody, prosecution cases. So regarding timing, date of offense, manner of offense, eyewitness one, then the victim himself, question of enmity, other things doesn't arouse in this type of cases.
Yes.
So my respectful humble submission, concurrent findings, first appellate court, scrutinize the entire record. Trial court has convicted the accused. The appellate court has scrutinized the entire record, elaborately scrutinized the entire evidence. So it was this application remission is liable to be rejected, Lordship. Minor contradiction, the imposition of the sole victims cannot be thrown away, Lordship.
Okay.
That is the main submission.
Yes.
Without even there is no corroborative evidence. The sole testimony of the victim who has seen the incident.
Where is the detention of the car?
Detention.
If it is not seen, there will be a detention. Where is the detention?
There.
30?
57.
Page number 57.
Detained in that car.
What is the date of the seizure? Detention? This is Supurd ki nama.
No, it is handing over.
That's why it is where is the detention?
Never activated.
I guess they are record. CD.
No.
In respect of equity, there is a scissor.
Correct. That's I want to see where is this detention memo.
Respect of car.
Where is the detention memo? No detention. So how Supurdgi?
That car Maruti Swift detailed list in the CD version. Was not in the CD.
See, Supurdgi, this either Caesar memo or
No.
detention.
Detailed list detention memo in respect of that car. Maruti Swift be that car.
Where is the Caesar of the car and this is scooty?
Scooty is the page number dated 7 June. Okay. 48. 48 constitution.
Kindly come to the exhibit 5. 5 by 1. Exhibit P 5 by 1. So if we go by this, detention and P5 by 1, that is a detention memo. Correct. And kindly come to the page 48. Caesar memo. And kindly come to the FIR. What is the time of FIR? (12:15 AM) hours. 12:15. Correct. Then the Caesar was made at 120. 48. There are two witnesses, Srinivas and Mohammed Ismail. Now come to the detention memo.
Date is 7 June 2000.
Same. 13:30 before after 10 minutes. After 10 minutes. Okay.
Before, because the police reached the spot, recorded the statement for the man, that is, thereafter refer to station, timing is correct. Then Caesar, then detention 13:30.
Okay. Any further?
Lordship, my respectful humble submission is that there was good evidence before the trial court, including the.
What would be effect of if the witness will say before the court that my statement is not recorded? What would be the effect of that? If the witness is examined, and during the cross examination, witness say that my statement is not recorded, what is the value of the witness?
Deposed. We have to consider both cross examination as well as the deposition.
That's why, see, witness to say with regard to the 161. He is not the witness on recall or anything else.
No.
Correct. It is not the witness, additional witness you want to examine. He is the witness, charge sheeted witness, listed witness, and you have brought him. If the witness say my statement is not recorded, what would be the effect of that?
No. After Lordship, that part, my contradiction, doubt can be created that my statement recorded by the police never recorded. But if this court found that the evidence in chief, which was recorded before the court on court, that's
why the court asked with regard to the injury report. You are not examined, not exhibited the injury report of the PW9, then the accused. So
that was not accused.
Then,
That was not. But my some assumption is that all are minor contradictory statement, Lordship. Enter evidence, the evidence of the victim cannot be.
Okay, that's all.
That's all.
Yes, Mr. Longo. And what, just what about this sketch map? To skid mark, what presumption the court will take?
Lordship, the car showing there was scratches of the tire, but case registered against the rider of the scooty.
I am telling, if the car is going from the Sinclairs to the Maza,
Lordship,
the car from the footpath side, because you are walking on that road,
Yes.
you know that very well. That is the footpath side, correct?
Lordship,
And the scooty is coming from that, there was no footpath, there was a nala. So as per this, scooty went on a wrong side.
wrong side.
We can say yes, a skid mark is there, 11 meter, whatever it may be. Scooty went to the wrong side.
Wrong.
Presumption can be drawn. But if the car, why the car skid mark from the left to right?
Lordship, that's, may I submit, Lordship? My case of the prosecution in respect of the accused was right in the scooty, Lordship. Something was happened, why due to the rainy season or other thing, why the car was speed. But
And you are not examining the Peter, this investigating officer, he died. So he-
non-examination,
the accu-
the eye was-
Now the accused could have been taken the clarification from that skid mark.
But.
Because
non-examination,
see,
the eye
for
was-
the criminal trial, you are the PP, you know what are the documents is important for the criminal trial.
But non-examination of the IO is.
Non-examination of the IO is correct. It is not. But if the document is there, if the chance is not given, and the police officer who examined instead of the investigating officer is not able to explain that, what would be
That is
affected?
correct, that is correct. That is within the record. Within the record. Right.
Okay, thank you.
But my, that is my, let's go.
Yes, Mr. Ilanga, anything further?
So, I was trying to explain this right plan, which even I had overlooked it. But after your lordships have raised, I could clearly identify that the skid mark started from the left side of when the two-wheeler was going. Similarly, the skid mark started from the right side when the car was coming. That means the car was in the wrong direction. This clearly reflects that. That's all.
So Mr. Ilango, and appearing for the petitioner. Has hearing concluded, CAB. Thank you. Next. Give. Yes, who is appearing? Item 9. 8. 8 to? Achha. Nobody filed an application for expeditious disposal. Nobody. Not today. Next. Yes. Yes, madam. Why you are not taking the final decision after the interview?
Not after the interview.
Huh.
Date of interview is cancelled.
Interview not conducted?
No.
Why?
Raised by the headman of the Kumari tribes.
Ah.
So
Where is that?
interview was there.
Interview was not held.
No.
Only the date was fixed.
The date was fixed, we were put and on the day of interview, around 9:30 or so in the morning, we got a call that the interview has been cancelled and the fresh date will be informed to us later. And moreover, the objection my learned sister is talking about, had there been any objection, then it should have come within time within which this particular.
Now, whatever it may be, you have to take decision.
Fine.
Take decision. Either this way or that way. What purpose would be of keeping this? If any objection, whether the administration is based upon the objection of the any of the category, if the statute provides such thing is to be done. If objection has been raised, like objection only with regard to one of the category, can the administration sit tight over the matter?
Moreover, had there been any objection, then in the first place itself, we should have been given an opportunity to file a representation against that objection in terms of the rules and talking.
Not you. This is the administration to decide the objection first. Then they can.
No, the notary's rules say that.
This rule with regard to the objection against in
Only,
person.
yes, and only.
Against in person.
Yeah.
Here is not in person. Here the as per service because
No, it was against two persons. It was against two persons only.
For what? They don't want the notary public in the Nicobar area.
Tribes that some students or employers, so they will be deprived because once a notary is been assigned, it's for lifelong. So our.
It's not a life
It's
law.
not very.
Okay, I am not going into. I am directing the authority.
Yeah. You know, what I was, like, the number of posts vacant since a long time, fine, advertised. Incumbents only 2. Now, there is an option, even not to conduct any interview for the lawyers who has practiced more than 10 years. So directly they could have given us, that's what. Provision is there. I'll let you do this on.
Mr. Goldar Lana, advocate appearing for the petitioner, submits that the petitioners, being the practicing lawyer of this bar, have applied for appointment of notary public in terms of the advertisement issued by the administration for appointment of notary public in the district of Nicobar. Police. And as the petitioners were eligible for this, for being appointed as a notary public, the administration has issued notice to the petitioners for personal interview.
My apologies, it's only one petition.
Petitioner, not petitioner, only petitioner. For interview. On which is scheduled to be held on
5th of September 2024.
5th of September 2020. Full stop. It is submitted that on the very same day it was informed to the petitioner that the interview is postponed and the next date will be informed. That is correct.
Gotcha.
Next date will be informed. The petitioner submits that till date no intimation has been given whether any interview will be conducted or not, or whether any notary public in terms of the notice issued for appointment of notary will be appointed. Learned advocate appearing for the Ms. Babita Das, learned advocate appearing for the, yes, you are the PP. Learned advocate Babita Das, learned PP and the PP appearing for the administration submits that the administration has received an objection from the tribal council. Tribal council. From the tribal council for appointment of the notary public in the district of Nicobar. And as such, the respondent authorities have postponed the interview. At the learned council for the respective parties peruse the materials on record. This could find that the administration has published the notice for appointment of notary public in the district of Nicobar in the month of February 2024, and On receipt of the application of the petitioner, the notice of interview was also issued in the month of August 2024 by fixing the date of interview on 5th of September 2024 at 11 a.m. But the administration has postponed, but on the date of interview, it was informed to the petitioner that the interview will not be will be postponed, and the next date of the interview will be informed, but till date, no date has been informed. Considering the above, this court find that no purpose would be served by keeping the present date application pending. Thus, the application is disposed of by directing the respondent authorities, particularly who is this district magistrate or deputy commissioner? Deputy commissioner, Nicobar district. So you have to attend the interview in the Nicobar.
No, here, we were called here to the second.
क्या बोला? Direct the respondent authority, particularly that he will be the or the sec.
Should be on respondent number 2 and 4 particularly.
I am giving the 2. Now क्या बोला? Respondent number. This one by directing the respondent authority, particularly the respondent number 2, to complete the process for appointment of notary public in terms of the notification, in terms of the vacancy notice issued on 17 February 2024 within a period of 4 weeks from the date of communication of this order. 6 weeks. DPS disposal.
Okay.
Next.
Number 4 and 3 from number 4.
Lordship, I am hearing for the respondent.
Yes, who is for the petitioner?
Lords, harassment appears on petition. I heard this manual. I heard
When he will get well?
past 2 days.
When you are better, when his rest will be completed? You have not taken advice when he will be able to come to the court.
Let the matter is to next week.
As per prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 7th. Next. Yes.
That's plan number 1, 2, 3, and 4. But if there is a direction upon me to file opposition version, the opposition is not ready and taking a big extension of time.
What is the prayer?
In a last hearing, survey number 111, 112 and 113.
111, 112.
112. I not here, the petitioner is the resident of a litigation that has be residing, it's the property which is recorded in the name of Manindra Mandal.
Private dispute.
The private.
Civil suit is pending. Civil suit is you are appearing for?
I.
Who are you?
Private.
That's why you are objecting for this. For what? For why? Why you are objecting? Huh? Who is your senior? So what is your objection? Electricity? Throwing out through the process of law. Electricity will be disconnected.
Actually, difficulty is that the writ petitioner is not the recorded tenant, neither he is claiming as an encroacher of the property.
So he illegal occupier. Illegal occupier of the
And
property in question of the private estate.
There was a connection in the name of Manindra Mandal, who is the recorded tenant of the landed property. After his death, his wife and his all children given no objection, and his wife has written a letter to the authority to disconnect the connection
of the petitioner.
No, in the name of her husband. The meter which was allotted in the name of her husband, that has to be disconnected.
Correct.
So we have disconnected it.
So how that is connected with the petitioner? The petitioner was enjoying that disconnection, that electric connection.
No.
Why? Petitioner was deciding that I got eviction and proceedings. My lord, if they are, that is the thing which is disputed. They were not residing in that premises itself.
So how this court
That
can
was-
decide?
My lord, they come to elected people in.
P13. Page number.
56 and 57. My lord, may come to 57, page number 20. It is clearly stated that this is a family matter. That's the reason they have disconnected this matter.
No, that is not true.
On getting, okay, file affidavit.
That's why we are playing for extension of time.
Then advocate appearing for the state respondent as well as the private respondents prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, thereto be filed within a week thereafter. List the matter before the appropriate circuit bench.
Okay.
Next available circuit bench. Next.
Lordship, there is a direction upon the petitioner to file a supplementary.
My lord. It shows the submitted by the other side. Where it has been.
File supplement incorporating the copy of the relevant document. Have you filed the affidavit?
My bank is not for me. Got to check.
So when you file,
Yeah.
as per prayer made by the counsel for the petitioner, case adjourned, let the matter appear on 8th of August, 8th July. Next.
I'm appearing for the.
I move this petition on the
Huh?
I move this petition on the calling P. Kannan.
Yes.
For electric election. And client has applied. That is page 11. On
It's a beautiful house. You don't have an electric connection. You have constructed the beautiful house that to RCC and you're not having the electric connection.
That's why I am before the lordship.
Yes.
So your page 11.
Page 11.
Applied on 5th April.
Page 11 is your Aadhaar card, sir. Page 10 is a photograph. Page 11 is your Aadhaar card.
Page 12.
Page 12.
Page 12.
When you applied for 5th of April.
5th April.
Yes. Then
Even after laptop 1 month.
Lordship, not connects under consideration. So related direction be given in accordance with law, we will dispose.
So suffering for the petition. The petitioner has filed the present application for grant of electric connection. The petitioner submitted the petitioner is in settled possession of the land bearing survey plot number 1 by P. Jawahar Nagar, Ward number 2, Calcutta, and has constructed a house in the said landed property and residing along with the family. The counsel for the petition submitted the petition has applied for grant of electricity connection on 5th of April 2025 and also affirmed the affidavit stating that the petitioner is in settled possession of the said property, but in spite of the same that the authorities have not provided the electric connection. Counsel for the petition respondent, Mrs. Satish Mishra, appearing for the electricity department, submit that the application is under consideration. In view of the above, the respondent authorities, particularly respondent number 2, Assistant Engineer, Electricity Department, dairy farm. Dairy farm. Dairy farm. How it is a dairy farm? So you are requested. And the Assistant Engineer, Electricity Department, Patrapu, is directed to consider the application submitted by the petitioner for grant of connection and to provide the electric connection within a period of 4 weeks on compliance of all formalities.
Okay.
WPA disposed of.
Generally, I used to appear from the electricity department, but whether they have served the department or not.
Who is there?
Send it. It's little under one.
Little under.
So it's not in Excel.
Give the copy. Give the
Very
copy.
difficult at plan. I can accept, you can accept, I can give it to sir with the response.
Mr. Jabal, I am not hearing you. Send any junior.
No, it's proven. It's purely proven. If I know, I can swear on you. It's purely, it's purely proven.
Okay.
It's a fact.
Give the copy tomorrow.
Yes, that's it there. Let me take it.
Learned counsel for the petition handed over a copy of the writ application along with the annexure to the learned counsel for the corresponding authorities. Let the matter appear. After tomorrow, क्या date है? Appear on 4th.
Okay.
Yes, next.
Same. I have not. Then everything's day after tomorrow. So.
Same order.
Okay.
Next.
Let's start on appeal for the applicant here, matter.
Yes. What service is of FMAT?
Lordship of memory, the fourth piece. Which the fourth things that it should be, please, as per the fourth piece act. The case has been dismissed. Challenging that we have done. Even though opportunity was also not given to pay the fees. Same day, it was said that the fees has to be paid, and on the same day it has been dismissed. Challenging that we have come, but the problem is that the other side is not getting served. Yesterday we received the envelope saying that it is not served to the other side.
Where she resides? E or C, whatever it may be. What is the address? Working as head constable. PS Chatham. Where is posted now?
This I retired.
Retired. Working as constable, PS Chatham, Armugam, Raju. So how they will served? Dairy farm.
Before the learned court, the trial court, in the same matter it was served. And they appeared and thereafter it went expired. But now, so we have to take steps.
Who is appearing? Nobody is appearing in the court. Insured. Michael is insured or not?
Vehicle is not insured.
He is the owner. Armugam is owner. And Satyanarayana is the driver.
Yes. Satyanarayana is owner.
Owner.
Yes.
And Armugam is driver.
Armugam is.
So, time fixing next week. Serve the copy. As per prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 7th. In the meantime, the petition director serve the copy of the application to the opposite parties. चार तारीख का. Yes, next. Yes.
During currency of the injunction order, election proceeding was initiated.
Currency of injunction order.
Election came from the order of please wait. Kindly come to pay meeting. The application is under section 10.
Public premises.
No, contempt of court act.
No, the interim order was under public premises.
Interim order is a civil court's order
Civil
based on the lease agreement.
Okay.
Page 18.
Page 18.
Yes. Kindly
25 good case succeed on the no notice was served upon. Eviction civil court got the jurisdiction.
thereafter kindly 21. The operative portion is at page 21. The defendant number 4 and 5 are thereby directed not to evict the plaintiff from the suit premises without due process of law.
Yes. What is the
That-
date? What is the date of the order?
It's
3rd January.
January, yeah,
3rd January 2019.
19.
Yes.
During currency of this order,
Hmm.
eviction proceeding was initiated by the estate officer.
Where it is? Where is the notice under?
Now I am coming to that. Kindly comes to the eviction order itself, page 50, 50.
50?
50.
Yes.
This is the eviction order.
6th May
6th May,
2025.
passed, and it was sealed on my premises.
No, see this order dated 3rd January. It was continuing.
Yes, yes. Suit is pending. It is-
No, the entry mode is extended from time to time.
No, it is still disposal. Kindly come,
Instead of engine is allowed on content.
still disposal it is there.
Where it is?
Page 21.
I never.
That instant petition claim for temporary injunction allowed on contact with no order of power. Defendant number 4 and 5 are directed not to evict the plaintiff from the suit premises without due process of law.
Correct.
This order was passed. Now kindly come to the eviction order appearing at page 50.
Yes.
Page 50.
Yes.
Page 50 is the eviction order dated 6th May 2025. Now kindly come to sealing order appearing at page 53. By passing this order, the premises was sealed during currency of the injunction application. Injunction order,
21st May.
21st May. It was sealed for 20 days. I challenge this order, page 50 and page 21, before the land district judge. Now kindly come to my supplementary evidence. Court granted leave and filed on supplementary evidence. Only the order copy of the land district judge.
Okay.
This order was passed on 9th June 25. The finding recorded by Leonard District Judge
Set aside.
at page.
That is set aside.
The eviction order was set aside
Correct.
and they given question also.
Hmm.
My respectful submission before this honorable court is there. How they can proceed during the currency of this injunction order? This is the first question. Second question is that prior to this order, already one eviction order was passed. Prior to that, kindly come to that order also. That order is appearing at page 38 of the original unit. Kind of documents. Page 38.
Yes.
Page 38, it starts from page 38, operating portion is page 44.
The state of the same is allowed on contest.
Set aside and remanded the matter to the Leonard
State office.
estate officer to decide in accordance with law. I challenge that order, district judge order before the High Court by filing a civil revision application. Kindly come to that order and appearing at page 46. Page 46.
Yes.
The operative portion is page 47.
In which he disposed of permitting both the parties to take all points available, including the points of jurisdiction before the state office.
Neither he decided the jurisdictional issue, nor he considered the stay order granted by the Leonard Court below. Kindly see, it is made clear that there has been no expression on merits of the case, and the estate officer is liberty to adjudicate all issues, including the question of jurisdiction, without being influenced by any observation in this order. The impugned order dated 6th August 2024 stands modified to the above extent only. Liberty is also granted to the petitioner to raise the issue of pendency of the civil proceeding before the estate officer, which shall be dealt in accordance with law. Now kindly see the order passed by the estate officer. Neither he considered the order passed by the High Court, nor he considered the status quo order granted by the Leonard Court below. He simply observed, page 50.
Okay, let the notice be issued, let the file affidavit.
They filed on complaints.
Where is that? Affidavit on behalf of the alleged contempt now.
Yes, they filed a complaint saying that in terms of the order passed by the Union District Judge, we handed over the possession. That is not my case. This is absolutely misuse of power by the estate officer. He should be taken to task for violating the court's order.
Yes, where is the justification?
But there are two contempts initially. One contempt is from the order of Justice Ravi Kapoor, which has gone to main event. That is the High Court order.
That is different thing.
So this contempt, because so far this contempt only when it dealt with the district judge's order.
No.
First of all, district judge.
No. Whatever it is, there was an interim order. Correct. Though the court has passed an order to take appropriate steps in accordance with law, you have initiated the proceedings and locked the premises. Lock the premises during the pendency of the existence of the interim order. Then he has challenged that your state officer's order that was set aside. Correct. So where is the justification in between when you lock? Where is the justification?
I will have filed a better affidavit.
What better affidavit? Let me appeal.
No, let us find out a bit because if your lordship will see there are two parties. One is the Directorate of Health Service. They are the main parties.
Who had put the law?
The state hospital.
Then-
He was not the party in the contempt.
Yes,
Sorry, he is party in the contempt. He was not the party as before the district.
Huh?
What he is making.
Who has passed the order? State officer.
The state officer passed the order, but he was not a respondent before the district. If I am not wrong.
State officer. And how the state case can be initiated without this?
Yes, it's not required.
Huh?
You are saying.
Can you see page number 38?
It's making sufficient content to records. Estate officer is the main respondent.
Yes.
So respondent number 2.
It can't be without the state officer. How the order can be passed?
They are not making the estate officer.
638.
Kindly grant us and shall file a better affidavit explaining all the circumstances.
No, my lord, I am praying for issuance of
Today, my lord, the position is that we are granted.
It's correct, but during the that's why I'm telling where is the justification you have?
The house is not intentional, my lord.
No, it's
Contempt, my lord, should be, my lord, intentional. my lord.
Intentional.
But that, my lord, we shall explain in affidavit, my lord, how it is not intentional.
week they have to file. They
So-
should not skip it.
So suffering for the learned advocate appearing for the alleged contempt, press for file supplementary affidavit.
No, that was already allowed.
No, for the alleged contempt. Press for time to file supplementary affidavit. Let supplementary affidavit be filed within a week. List the matter on 9th July.
Great.
Right.
Next.
It's a report of the phone.
Mr. Vijayanpal, the time to file opposition. Today, nobody is appearing. This is application for.
That of the affidavit officer.
Application for substitution. I filed, there's a delay. Along with section 5, I have filed. And on the last occasion, the other side.
Where is Vijay Kumar?
On today, he's not appearing. 1 year, 5 months delay is there.
Who died?
The dependent.
Soul.
So.
So what is the objection?
We took time on the last occasion, we will file opposition. Today, nobody is here.
It's not direction of the affidavit, only take for time to file वकालत नामा. Has he filed? वकालत नामा आया है? नहीं है. Where there is at the legal years?
Legal years, paragraph 5, eviction, 4 legal years.
Now where they are residing?
4 of them are residing in Blair and 1 Your Lordship, there is an Andhra Pradesh.
Okay, I am fixing a date next week, Tuesday.
Yes.
You inform the only. So and so appearing for and none of so and so appearing for the appellant, none appears on behalf of the respondent. It is signed from the record on 10th of June 2025. Mr. Vijay Kumar, an advocate, raised for time to file wakalatnama on behalf of the legal heirs of the deceased respondent, but this court find that no wakalatnama is on record. Today, when the case is called, none appears on behalf of the legal heirs of the defendant. This is defendant, and this is respondent. For the interest of justice, the case is adjourned. Let the matter appear on 8th of July 2025. The learned counsel for the appellant is directed to inform the next date of hearing to Mr. Vijay Kumar. Yes.
But in this matter, for respondent, Mr. Tulsi Lal is there. This is they are paying for regularization and 1/30 benefit. Mr. Tulsi Lal is not there, but he is going to gain benefit as indicated yesterday also. Because
Where?
mainland for his health matter.
Okay.
Health treatment matter.
He is for the respondent number 4. Who is the respondent number 4?
He's for the main respondent.
Who is the
District courts.
in our court?
Now, I have taken out an application, which will be coming up tomorrow. Because after this order, 1/30th benefit was given in terms of the office memorandum of 22nd September 2017. And the administration time to time extended their service continuously. But while issuing the extension order, artificial breaks are being given by the respondent. Despite of the fact that the administration is extending it continuously. So I have taken out a CAN application, tomorrow it will be listed.
Let
So
it
let it appear tomorrow, just not this.
not today. Next.
21, that was 2023.
Who is for the municipal?
So Sivabalan is available.
You, Partha Sarthi. Yes, what is the case?
You're paying for a demolition of an illegal construction, which was carried out after passing of the stay order by the municipality. There is a provision, the 32(6)(7) says, I'll file all the documents.
To take action in terms of clause 32.7. Where is the notice? Where is the order issued by the municipal authority staying on stay order?
It's at page 24.
Page 24. 2023.
2023, my lord.
Then
Thereafter, they have already, during this stay, they have constructed.
they completed the
They have
construction.
completed.
Yes.
That report is there, my lord, because I've annexed all the documents, all the photographs, and lastly, can you see? in the-
No final order is passed.
Yes.
No final order is passed. Where is that?
So that has passed later.
Hmm.
Now, during this period, during this stay, they have constructed.
Correct.
Now I want the permission.
Correct.
And
Initially, the municipal had issued the stay order, but they have violated the stay order. They continue with the construction work. They have completed the construction. Correct. So the municipal has issued the provisional order for demolition.
Yeah.
When it was issued?
Yes.
What is the date? Binu, you are appearing.
Yes, I am appealing for the private.
So have you prepared any appeal? No. Again,
Was passed.
no final order is passed. So I am directing to complete the.
Can you see, there is a report, site inspection report. After the stay order, no construction was carried. municipality has given a report that is part of the case record.
Inspection report.
Yes.
Unlawful construction in violation to the municipal, like the subject of, no, that is page 29 is that the construction is going on.
12th October 2023, there is a order. I can give my copy. It is there, in the court record, it is there. I have seen it in the morning.
Already filed everything in August, wherein they have admitted that it has reconstruction was completed.
This is a,
They have already filed the report.
this is a report.
Second report finally
This
this
is of the order passed by this court.
Yes.
Now, my lord, we kindly see my objection. The everything cropped up when the Tahsildar has passed an interim order. Page number. My opposition is consisting of at least only 10 pages. Cannot see. My lord, we kindly see there is an order of
Response number 3.
response number.
You are referring for 3. Sudeshan.
No,
Sudeshnan.
no. I am appealing for Sulaka. I can remember there were 2 cases. All were tagged together.
One is dismissed.
No, that was altogether problem.
That was dismissed.
That
On the
was
application on April 30th.
So what is the situation as
Now-
present?
Kindly see the affidavit of operation filed by the respondent number 1 and 2. They have annexed the document by saying that yes, construction was done, everything they have said. They have admitted. They are the person who can see all these things. Madam. They have admitted. They have annexed the stay order. They have to kindly see site inspection report. Second site inspection report. This is the second site. They have annexed along with the affidavit of operation. It is mentioned.
Yes, same.
After the block letters, it is mentioned in compliance with the order dated 25/5/2023 and 29/9/2023. 2 different dates, May and September. The site has been inspected by the concerned building inspector. During inspection, it is observed that no construction activities are going on at the relevant point of time. The complainant. However, the council had issued the stay order on 1/3/2023 at the relevant point of time when the March it was construction was going on. Again, my lord, against the unauthorized construction and subsequently a notice being dated 24/2023 and a provisional domination order dated 4/8/2023 has been issued. So when they have inspected.
Okay, let I am directing the proceeding initiated the municipal council be disposed of.
No, my lord, what happened? Thereafter, my lord.
One second, one. And lastly, kindly be seen, my lord, further in addition to this, the party has submitted the building plan for revalidation.
Correct.
Which was returned with the observation that the building at site is not tallying with the approved building plan. What I am saying, without the building plan, they have come to my land and they have illegal constructed. That is my case, my lord.
Okay, now this court cannot decide. This court will direct the Secretary Municipal Council to the proceeding initiated against the private respondent be concluded after hearing both the parties within a specific time. You raise all the objection before the Secretary.
When there is a violation, there is a provision to demolish it.
Correct, that's why they have issued the stay order. So
There
that's
is a provisional order.
correct. So now that he has to pass a final order, let the opportunity be given and demolition order will pass, it will pass, it will not pass, then you
Within
are.
a certain time.
Yes, I am
My
fixing.
lord, since my opposition, my lord, the entire issue was cropped up by passing a stay order. My lord, may kindly come to that stay order. I will just place 2 aspects and thereafter I will not make further.
Stay order Tahsildar.
Tahsildar. Now,
Yes.
We find that Tahsildar says whereas a complaint was received from Sudeshan, so and so for illegal construction upon the land bearing survey number. My lord, may kindly see survey number 639 by 1/1. And whereas a report called from the so and so, and as per record classified, situated, recorded in favor of Sulaka and its group, it is trying to stop the ongoing construction. Now, my lord, may kindly see, there is a vacation order, next page. Whereas a stay order has been passed in RC case number so and so for illegal construction of 639 by 1/1. Now, my lord, can you see third paragraph? And whereas a report obtained from the revenue field staff which reveals that a retaining wall is being constructed on the land bearing survey number 639 by 1/3 situated at so belongs to Sri S. Sulaka, wife of Chandrachуда. Now, my lord, that everything cropped up on the basis of the stay order issued by the Tahsildar. Now, my lord, Tahsildar rectified after the report saying that the retaining wall was constructed in her land. This is one part of the
Where is that order? Where is the report?
my lord,
Page number?
last page of
No, you're not exposed. Only stay order, page number 11 and 12. There's no other order.
my lord, actually matters were there, my lord. Why some documents are missing, my lord. This was served the contract. I'm sorry.
This order is okay.
That paragraph, my lord, sees they have clarified that on the verification report was called for and it was found that she is carrying the retaining wall in her land.
Correct.
Now, my lord, second aspect. I have filed a suit before the trial court wherein my London friend has taken out an injunction application stating that we are pursuing with the construction work. Court has passed an interim order. Thereafter, my London friend has filed an application for appointment of commissioner. That is pending. So, my lord, my London friend is taking recourse before all the court, Tahsildar court, civil suit she has filed where there is an injunction order. Now she has approached the High Court. I say that, my lord, all the parallel proceeding cannot be initiated. Particularly when there is an interim order passed by the trial court. Trial court has stayed the further proceeding. And my London friend filed an application for appointment of commissioner. That was also allowed. So I pray, no interference is required for so far as this part is concerned. Let everything be decided by the trial court when the matter is before the competent court of law.
Trial court, it's okay. I am not interfering with the trial court, whatever it is. With regard to the authority, where the complaint has been filed, who is the authority to grant the sanction plan and to look out whether any building plan has been violated or construction has been made without the building plan or violation of the building plan. There isn't one authority. Let the authority decide.
Now, one more thing. These petitioners are not the recorded owner of the land. They did not have any right in respect of the said land.
Which petitioner?
This
This petitioner?
petitioner
Okay.
is not the recorded tenant of the land.
How you have been affected?
Yes.
But here, my father has executed a will on the basis of.
Oh, sorry.
No, I also thought, but
But due to personal reason, the matter is released. You are also not in then.
the documents which I have read.
Document दो document. वो नहीं ये क्या है ना yeah. Yes. Next. Which one? Sailors Union.
I want to argue the matter because an amendment is not appearing.
I can't approve because it's taken back the brief.
I will argue, my lord, because the thing is that without any cause of action, a case has been filed without airing me as a party who would be affected. I took out an application whereby this court aired me as a party. Now, my lord, you kindly see.
What is the prayer?
Now, my lord, you kindly, I'm just placing this.
You are appearing for whom?
For the petition. Petitioners are not allowed to contest the election, million elections. For that reason, it was filed.
My lord knows very well that.
But it's violation of constitutional right. But since I don't hold the brief right now, I'm deprived of making it.
My lord will find that before this majority union was called, a meeting was there. Now, my lord may kindly see page 21. They were given ample opportunity. They were a party to that. My lord may kindly see page number 21 of the writ petition. This is the minutes of the meeting whereby majority union was decided.
But there is a report of labor.
No, my lord, can you see?
There are certain things.
And this everything.
Okay. You do one thing, Mr. Binu. He is withdrawing the power. So you issue the notice. Come on the next day if you are withdrawing the power.
He has taken back the brief.
So somebody has to represent. Otherwise, I have to dismiss.
I'll give the notice.
Next week.
Mr. Rakesh Govind, an advocate, submits that though he was appearing for the petitioner, but the petitioners have taken the brief from him. Foolish. When the matter is called today, none appears on behalf of the petitioner. Accordingly, for the interest of justice, the case adjourns. Let the matter appear on 4th. On 4th. Yes, next. Yes. Second appeal. Affirmation or concurrent finding? Yes.
Eviction. And your lordship, I will directly, your lordship will take your lordship to the cross-examination of PW1. And then I will come to the questions of law named by the Honorable Court.
Yes. Where is the DW2?
Page number 32, PW1.
Yes.
Starts from page number 32. And the relevant is,
Before starting, I filed 2-3 can application
For?
for filing some documents. And then it will pray for filing objection to that.
because that will be taken up at the time of hearing. No new documents can be introduced. Your lordship knows it, this is the second appeal. So I will make my submission accordingly.
No new document, it's not a new document.
These are new documents, which are
It's
not
the
a part of
elected
the trial court records.
Yes, but it is very much essential.
It will be seen by your lordship whether it can, it is.
What is the, where is the application?
Three cans.
Can number?
File 3 cans.
Can 1.
Can 1, 2, 3.
Order 41 rule 27 additional document. Additional evidence. Then
Can 3 is for order 47 to 27.
order 27 47 rule 27.
I received it. Reply for can.
Allow the applicant party instruction. Where is the other can? One है बाकी कोई can है वहाँ पे और कोई can है क्या?
And
Only one can is there for additional document.
3 can application I filed.
It's got basically no relevance.
What is up there?
Relevance is there.
Can 2.
Yeah.
Can 2 is for
Can,
To treat this application part of the appeal.
yes. And the which provision of law this type of can is filed, I know.
can 2. Can 3.
Can three, he wanted to introduce certain documents that will be heard along with the other.
No, can 3. Can 3 is therefore graciously pleased to allow the application as part of the instant appeal and pleased to dismiss the appeal.
Whether you want to file any objection to that, if it is not, then I am ready to. This.
Yes.
Come on.
Not today. Come ready tomorrow then.
Yes. I'll give advance copy evening.
Next.
My senior is.
This is line of.
Who is your senior?
Ajay Kumar.
Ah.
He's,
Let you take the note. Let's see argue. He will come and you argue. Second appeal. Concurrent. Here also. Reversal.
For specific performance. When you also I take your questions of law which has been created.
Power of attorney holder becomes non-est in the eye of law, notwithstanding. Yes. Three questions.
Yes. Case is that, Your Worship, there was an agreement. Basically, the agreement was in the nature of a power of attorney, and in the power of attorney, the concept of sale consideration is mentioned, the amount which has been paid by the plaintiff to the defendant, that is also mentioned. The learned trial court considered that to be a sale agreement and granted it to me. The appellate court considered the same as a power of attorney and said that the person has already died, so power of attorney does not exist, and the relief has not been given. This is basically the. Now, Your Worship, one by one, I will this one.
You are for the plaintiff.
Can we leave the rest of the number?
You will continue. Yes.
The case is that one Nityananda Roy, so he was the husband of the defendant. And he executed one agreement in May 1980, an oral agreement was entered. And he agreed to sell 680 square meters of land. Survey number was 20/4, and the total consideration was 82,000. And that particular this Nityanand Roy received the entire sale consideration amount, and thereafter a physical possession was also handed. And then there was certain requirement, procedural requirements were there. Then a power of attorney has been executed, and it has been specifically given in paragraph 4 of the claim, which is at page number 3. You should be kindly come to page number 3, because here there is a power of attorney has been mentioned. And for the want of some procedural requirements on the way of immediate registration of the sale deed, the said Nityananda Roy could not execute the sale deed at that time, and instead thereof executed special power of attorney jointly along with his father in favor of the plaintiff with a promise to take every initiative to transfer said sold land in favor of the plaintiff as soon as possible. Now, Your Worship, thereafter actually this particular person has took the position, and that sale consideration was paid. He constructed the building also, and he spent 10 lakhs over that construction. Then Your Worship, he is continued approaching that Nityananda Roy. Nityananda Roy thereafter died, Your Worship, and his wife is there, who is the legal heir of Nityananda Roy. And when he approached the wife also, she also said initially that sale deed will be executed, and subsequently she refused. Now, paragraph 14, I have stated about the legal notice which has been issued by the plaintiff to the defendant. In the legal notice, demand was made. And
When the notice was issued?
Date and just
Okay.
I'll specify it. Then readiness and willingness has been specifically pleaded in the suit. So those requirements are completed. Now, in the written statement, they have totally denied. It is just a very specific description. Yes, paragraph 10 of the written statement.
Yes.
Both oral agreement of sale as well as paragraph 11, power of attorney, both the things have been denied. Now, Your Lordship, the evidence. First, Your Lordship, I will place the documents, Your Lordship, relevant to the case. And then I will place the evidence of the party. Yes.
Yes.
Number 62.
Yes.
It's a be it known to all men by these presents that he, Shri Nityanand Roy, son of Nitis, and Srimati Sarthi Roy, late Jagbandu Roy, both residents of Rampur, village Rangat Tehsil, Mikhandaman, on consideration to the receipt of sum of rupees 83,000 received jointly by us from Shri Abhilash Chandra Roy, son of late Charu Chandra Roy, in cash in full, and being token of which we do hereby jointly and severally in our joint names and also as our individual acts do hereby nominate, constitute, appoint, therefore said Shri Abhilash Chandra Roy, son of places, resident of this Mikhandaman, to be our lawful, true and lawful attorney in our joint names and also in our individual names, and acts to do or execute all or any of the following as deeds and placed in respect of a part of landed property measuring an area of this out of the total area of this, which having an area of this and classified as hostel and comprised in OR holding number this, which holding having total area of this situated at village, this is this, about which particular part of land, more particular described should be 8 to 0, and also stands before a village and stream of Nityanand Roy and Sarthi. In the beginning itself, it is stated, after receiving an amount of rupees 82,000, this power of attorney has been executed. And all powers have been given.
Yes.
Power to sell, power to construct, and all the powers have been given.
Correct.
To pay the premium to the government, then to sell, to dispose of, everything, all powers given.
But it's a registered document. Registered power of attorney, sub-register, yes. Registered document, yes.
Yes, sub-register, ma'am, registered document. Now you know, shit,
So this is of 1988,
1980.
June 22nd, June 1988. Yes.
Thereafter, the record entry is there, page number 68.
Who is Sarati?
Mother. Mother of Nityananda,
Mother and son both.
both.
And this is only with regard to the 20/4.
This
The
is
survey number is 20/4 only.
2022.
Area is 1.19 hectare.
Yes, total is 0.19 hectares.
Out of this, you have been given 680 square meter.
Yes. 680 square.
680 square meters. Yes.
This is the record entry, page number 68. Thereafter, all no dealings and everything was obtained.
Correct.
To valuation was also obtained. Page number 78 is the valuation.
Yes.
So
80,000.
it's for obtained.
The value of the land is 80,000.
Yes, 80,000.
That is the total land.
Total.
Yes.
And then in notes, it is, I have written a letter, page number 82, to the Tehsildar.
It is of 2009.
Yes.
And these certificates were obtained when?
Different dates, you know, so one is in
Last.
1990.
1990.
Yes, one is 1986, also is there.
1990.
Yes, mostly are of 1990.
Okay.
Then I have written a letter also to the Tehsildar, Midlandaman in 2009.
When the Nityananda died.
Yes, date of death.
Okay, then what is happening? This is a letter. What is the request to the seller? Now come to know the mediation of land property and then already been completed in all respect also. Therefore, the request, this is neither refusing nor coming forward for registration. Yes, yes, then
Then notice was issued, page number 84. This is the notice which has been issued by the Tehsildar. And he asked that Subhara Roy to be present
correct.
before the Tehsildar. Then a proceeding was initiated
Yes.
before the Tehsildar. Though the Tehsildar doesn't have the proper power authority to do all these things, but as a complaint was there, so all the parties. Now, Your Worship, he has also suggested Subhara Roy that to settle the matter. This is in the first page of the proceeding. Thereafter, she had signed also the respondent, the second page 87, the respondent, Srimati Subhadra present, the complainant
Absent.
absent. The respondent reports before this court that she is agreed to execute necessary safety in favor of the complainant after disposal of civil suit by pending in the court of CGM court there. That is some partition suit was going on between certain parties. So she said that after the disposal of the civil suit, she will execute the safety. These are all exhibited.
Yes.
Now thereafter, this is a legal notice which has been issued, page number 91.
So what the Tehsildar has done subsequently
Nothing is
disposed.
Yes. Advice to seek appropriate civil suit.
Civil code, that is in 2010.
Yes.
Correct.
When nothing happened, we advise that we go to the civil court because from this particular court, nothing can be done.
Then you issued
Thereafter, also we have issued a legal notice.
in 13.
Yes.
Yes.
For getting the safety registration, legal notice was issued. There was no reply. She has received.
Where is the second page of the notice? Second page of the notice. 91. One page is missing. Oh, original record, no? Lower court record. Yes.
Thereafter, Your Worship, now I will come to the evidence.
It is not barred by limitation.
It's not time limit. So from the date of refusal.
So refusal when?
After.
Acha, the notice.
Because when notice was issued, when there was no reply, the suit has been filed. Because till such time, there was no refusal. She herself has submitted before the Tehsildar that she will execute.
Yes.
And after the issuance of notice, September 2013, the suit has been filed.
Okay.
Because we were expecting that she will be executing the case. Now thereafter, I'll come to the evidence one. PW1. Cross examination ABC.
Page.
Page 835. Page 35, cross examination. Exhibit 1 was executed and registered in June 1988. This is coming in the cross examination. Not the fact that defendant Subhadra Roy had no personal knowledge of Exhibit 1. Even no knows. That is, at least she has personal knowledge. I had no cordial relationship with Nityananda prior to the execution of Exhibit 1. The oral agreement between myself and Nityananda Roy took place in the month of May 1988 at the tea shop of Satish Das at Rangat Bazaar. Probably it was during the evening. The said tea stall had several customers, but now I cannot recall their names. Now I am leading a retired life and I help my son in his business who runs a shop of computer shop and Xerox etc. The name of my son's shop is Common Center and Trades and License giving his name. It is usual for my son to type letters leading to Tehsil office in computer, and he also sometimes files up the requisite form required in the office for those who require it. It is my son who used to work as DRM and Tehsil office lender. In my service life, I was the account officer of Fire. It is fair that I used to assist the meeting people in drafting petitions addressed to the Tehsil and other revenue authorities. Now I am residing on the street plan and even residing there since 1986. I came to Rangan on transfer in 1983. Not a fact, I started residing at the house of Nityananda Roy as I had friendly relationship with him. Since that I had no quarters at Rangan, or that relationship further developed as I resided at his house. It is fact that Nityananda Roy and Sarthi Roy did not understand English together. Not a fact that Nityananda is one asked for my help in selling half of the suit land as I worked at Pay Account Office London. The Exhibit 1 was prepared by one principal issue since received but not under my dictation. He had prepared Exhibit 1 upon the request of myself and Nityananda Roy and Sarthi Roy. This is important because all of them together have said.
Yes.
And this is coming in the cross examination.
Yes.
No certificate was, however, issued by the principal. The contents of Exhibit 1 was, however, not read over and explained to the principals by me, but by the registration staffs.
Yes.
Then this is not a fact. Thereafter, there was no receipt in respect of payment of rupees 82,000. Not a fact that I have obtained Exhibit 1 by practicing fraud upon the principals to my advantage. Your Worship, in the written statement, they have stated these documents were never executed. Now the cross-examination says by practicing fraud, it has been done.
Correct.
Not a fact, the principal asked me to help in selling the sultan to some other persons which I purposely converted into special power of attorney, or that because of the aforesaid fact, I never persuaded the principals during their lifetime but sold the sultan to me, or that for that there was no legal notice was issued at that time during lifetime of principal, or that I purposely waited till their death and long time thereafter. Not a fact that I did not raise any objection when the suit claim was indicated after subdivision. No, I have documented proof of such objection, but I have not exhibited those. Not a fact that I disclosed to the existence of Exhibit 1 in figure 2009 when she asked me to vacate the suit. Not a fact that I made any discussion with the legal aids of the principal from the date of execution of date of execution of Exhibit 1 in 2009. Sarthi Roy died in 1983. Not a fact that I did not request each and every principal of legal aids to transfer the full title. The suit was mutated in favor of Subhadra after subdivision of the same. Because it was mutated solely in the name of Subhadra after subdivision. So notice was required to be issued to her. The matter was pending before the civic
Partition.
leading to partition. Not a fact that the plantation standing on the suit line were raised by the principals. Not a fact that I had tried to raise. Then all this not a fact I'm not repeating. Then one Manoranjan helper. PW2. His chief is there, and in the chief is stated about the agreement,
Yes.
as well as he also stated about the fact of the position of the plaintiff in respect of the property in question.
Yeah.
And then what actually has happened, paragraph 5, 6, 7, I'm not repeating, these are the stories which are mentioned in here, that he knows that other persons have approached. And Nityananda Rai also was approached by Abhilach Chandra Roy relating to execution of sale. With all these things he has stated. Then he also stated that initially Nityananda Roy demanded 90,000, but ultimately the amount was fixed at 82,000. Then at page paragraph 8, he stated about the payment of 82,000.
Yes.
paragraph 9 also.
Okay, Chief, what is the cross?
Now, cross exams. I have received summons from the court. The affidavit in chief has been prepared by another advocate of the plaintiff. Plaintiff is a close friend of mine. Today I have come to the court with the plaintiff. I am not a signatory to the special power of attorney. As such, I am unaware of its concept. It's fact that either the Roy and Sarthi Roy did not know or understand English. There was no written contract between Nityananda Rai and plaintiff, but there was an oral agreement. The said oral agreement took place in presence of myself, the owner of the little Sarnistar, and some others whose names I cannot research. I have no knowledge whether Nityananda Sudra Roy was a signatory to the agreement or not. She can't, because her name was, that land was never mutated in her name at that 11 point of time.
Yes,
It was between Nityananda Roy, Sarthi Roy, and then Abhilash Chatterjee.
correct.
The plaintiff had forget the decision. With Nityananda also since she came to London on transfer. Not the fact that the plaintiff was a tenant upon the suit property. Not the fact only 200 square meter of land was agreed to be sold to the plaintiff by. This is very important deduction. Not the fact that only 200 square meter of land was agreed to be sold to the plaintiff by Nityananda due to his cordial relationship with the plaintiff. For that, please standing for the suit line was raised by Nityananda. So now again a change. By 200 square meters. There was a not a fact, no such monetary transaction took place in my presence. In that, at present, I cannot make a denomination of those.
Yes.
That is. Then DW belongs. 2 witnesses were examined, not DW. DW1, the cross examination, because she has repeated what is stated in the written statement. My age is 82 years. My husband Nityananda died about 20 to 25 years ago. I cannot say the date of his death. Sanjay Roy is my sister-in-law. I filed the case against Sanjay Roy at court there. I cannot say the survey number and the area of land in the suit filed at court there. The present suit property is different from the suit property of the case at court there. I know Abhilash Chandra Roy about 20-30 years ago. Abhilash resided in 150 square meters land and rest is in our possession. And the survey number of the suit property is 20/4. It is true that Avinash resided in the part of the suit from the year 1988. This is with regard to the possession.
Yes.
It is not the fact that Avinash purchased the land where he presently residing. It is not the fact that we have rented the land. We have given permission to reside there. My husband converted the township for temporary residence of Avinash. My husband at that time was a farmer. It is true that there is a written trees in the said 150 square meters of land. Not the fact that in the said land, Avinash constructed double-story building. Sarthi Roy is my mother-in-law. It is not the fact that my husband sold the said land of 680 square meters to Avinash in consideration of 82,000. I never heard regarding any power of attorney signed by my husband and mother-in-law in favor of Avinash. It is true that the house where presently Avinash resides has electricity and water connection. It is true that the land of Avinash is separately fenced. I do not know if Avinash is allotted with government quarter or not. But on being asked, we have given him permission to stay there. It is not a fact that Avinash residing in the land not on the basis of any permission, but on the basis of sale. It is not a fact that Avinash filed case to the testator for sale suit property. It is not a fact that I am deposing falsely in the court and we have received the notice of the testator in respect of the proceeding therein. It is not a fact that I have given statement before the testator that we have sold out the lands of Avinash and after conclusion of the case at court will give it to win by executing sale. I did not find any case against Avinash for eviction. It is not a fact that the entire suit land belongs to Avinash. It is not a fact that he has a total 680 square meters of land. It is not a fact that Avinash collect proofs, survey number is in my name, and then she denies about the notice.
Yes.
Now, Lordship, the documents which have been exhibited, all the documents have been exhibited without any objection. No objection. Specifically, I am speaking about the Tehsildar proceedings. Because those were brought before the court and those were exhibited, they have not raised any objection.
Yes.
The code of proceeding may not be recognized, but the contention which is reported by an authority that can't be ignored unless and until it is specifically disputed by the other side. Now, DW2. This is what Nepal Viswas.
Yes.
Now, I'm coming to the cross examination.
Yes.
I know the defendant of this case. I came here to depose her. The Bhati is her daughter and we came together to pay. I have not received any summons of the court. I came here as per request of Prabhati. Lawyer read out over the contents of the position on chief to me and it was drafted as per my instruction. Survey number is 25 of this case. I do not say regarding any other survey number of the defendant. Land was allotted in the name of Nityananda Roy alone. It was 30 acres of land. My house is 1 kilometer away from the suit property. I know Sarthi Roy, the mother of Nityananda. She is no more. I have no idea if the land was issued with the joint name of Sarthi Roy Nityananda. Nityananda Roy died about 25 years. About 10 years ago, the land was created in the name of Subhadra. About 28 years ago, plaintiff used to reside at London at government quarter. Now there is a double-storied house in the street property in the possession of the plaintiff.
Yes.
This was denied by Subhadra. Water and electricity is also in the name of the plaintiff. The house was built about 22 years ago by the plaintiff.
Yes.
The house of Nityananda Roy is about 200 meters away from the street land and fencing.
Yes.
The house of plaintiff is surrounded by fencing and the garden is also separately fenced. I cannot say who is the owner of the garden. There is few coconut, betel nut and other trees in the said garden. It's not a fact that there is no separate fencing for the garden and the garden is within the compound of the house of the plaintiff and in the possession of the plaintiff. I cannot say how plaintiff came into possession of the land and fenced the street property. I did not see the plaintiff to urge or request the owner for the delivery of the street land. It is not a fact that plaintiff has in his possession in total of 680 square meter. I have no idea. I have no idea regarding any notice issued by the authority at the time of petition or objective it or not. I do not know if plaintiff filed a case because there is no office regarding suit land. It is not a fact that such statement was prepared beforehand and I just put my signature in it. I do not know if plaintiff purchased the suit land from Nityananda Roy for an amount of 50,000. Plaintiff residing in the said land from 1982. I cannot say who was in possession of the garden. It is not a fact that I filed a false statement and it suppressed.
So possession is admitted.
Possession is admitted.
Yes.
88,
88.
yes, since 88, the possession is there. Now, justification with regard to the possession, that justification we cannot find anywhere in the evidence.
Correct.
Even in the cross-examination of Subhadra also, she is also disputed. But her own witness says that he is, and about double-storied building, she says there is nothing of that kind. But the witness says there is a double-storied building where Vilas Chandra Roy is.
Yeah, they have not taken any even counterclaim. They have not.
Counterclaim is there.
Counterclaim is there.
Yes, counterclaim has been allowed.
No, but he has stated that I
He
find
has stated yes.
Yeah,
I
I-
have not filed any case of
any
eviction,
case,
but counterclaim is there.
counterclaim.
And when the suit was allowed, there was no two appeals filed. Only one appeal was filed before the district judge challenging the judgment. And it was disposed of by a single judgment entity. That is the reason why even in the second appeal, I could not file two appeals. That is the problem occurred because there they have not filed two appeals. They were challenging the counterclaim, one appeal should have been filed and dismissal of the suit
Dismissal of suit
ought
and
to have been filed. But they have filed only single appeal.
against the counterclaim.
Yes, both together.
Whatever it means.
Yes.
So what the district judge has said,
Decrease the counterclaim, dismiss the suit. Recovery of loss.
where is the judgment?
Yes. Page number 105.
Of the
Paper.
of the appellate authority, of the appellate court.
Yes, yes.
Now, this civil justice senior division.
Yes, mention your page number 93.
The suit of same is decreed and decided in favor of the plaintiff and can defend his right to give registration. Children as per the schedule. The counterclaim of the defendant is dismissed for having now married. They are pleased to prepare the decree as per yes. Then where is the district judge?
Yes, 105. According to 111, that is the appeal, 111.
Yes.
The only thing the district judge has said is that the power of attorney has got no value because of the death of the defendant. And the complete judgment is based upon that particular. Kindly come to page number 170, the relevant paragraph.
Yes.
Having heard the learned advocate, rest all submission of the party. Having heard the learned advocate for the parties and on the reason of the materials, evidence and judgments of the court, I find that the suit property originally belonged to Mr. The lawyer and said it was the executed power of attorney in favor of the plaintiff on 22/6/1988. After execution of the seven special powers of attorney, both executed died within 2-3 months. So I find that the validity of the said power of attorney has qualified and it has become non-estate blinded. No right has been acquired on the basis of the said document, though on the basis of document, the right for being to get decision of the suit property. In the said exhibit 9, in instance of a lawyer agreement between the lawyer and the year 1988 is received. The existence of that oral contract will be reduced in writing in the said exhibit 9. In view of the position, I am of the view that plaintiff never acquired any valid right on the basis of exhibit 1 as it became honest after the death of exhibits in 1988. Claim of right on the basis of exhibit 1 is barred by law of litigation. The ruling as referred by the advocate for the plaintiff reported in this given in this case as a document itself is being likely understood. In view of the arguments, in view of the arguments as urged by the parties of the proceeding and on the reason of the evidence and each of the parties, I am also opinion that oral agreement is valid in the eyes of the but it should be proved by leading evidence. In whose presence the oral agreement was executed and their evidence are very significant for the nation that an oral agreement was executed between the and plaintiff. And this would date remain silent actually in whose presence the oral agreement was executed. That is specifically mentioned that who are all present and the person who was there, he has been examined.
Number 2.
Yes. To prove the contract, there must be offer, acceptance, consideration, money, intention to create legal relationship, lawful object, capacity to participate. The plaintiff has failed to keep the oral agreement, and in the absence of those, I am considered legal basis no existence of oral contract, and this is specific form of this could not be imposed by any law for a time. Such view of the time. The finding of the trial with regard to the kind of excellence and most not altered principle stated is not sustainable in the law. Another finding is of the trial court with regard to the fact that infringement avoiding the transfer by way of state is also inapplicable and cannot be sustainable in law. Moreover, it is crystal clear that the plaintiff did not come with clean hands as he did not disclose anything with regard to the oral contract in executive manner. It was made purposely by the suit as there is no existence of oral contract and for that reason the plaintiff did not disclose the same in executive manner. On the contrary, the plaintiff is claiming right for the basis of exhibit 1 where the validity of the document was promised after the death of this. Any order other than the reference on the basis of invalid document cannot be enforced in the process of law. That is settled law. Nobody is asking for that. From the pleading, it is clear. It's still clear that anything is in possession of this property as per the document dependently is actual owner of this property and same as particularly given and be the defendant by her competency pays for degree the revenue you can pay to locate the handover possession of this property. The user of the document is dependent is the recorded owner of the property and the plaintiff has no right, title and interest over the property and now he is possessing this property unauthorized. The findings of the trial court with regard to the fact that there being any paper regarding objection in his possession of the land by the plaintiff is not sustainable law as the possession of the plaintiff is unlawful. By finding not the defendant pays for taking. Considering the materials on record of the and on the user of the judgment passed the trial court act convenes to both the findings and observation of the trial court are not sustainable in law. And in view of above mentioned finding, the plaintiff has failed to prove the oral and as such, the plaintiff is not entitled to the fee as paid for. So in such view of the observation made in the body of the judgment and of the proceeding, there is judgment in legal part when both things are just another on panoptic consideration of the materials and evidence on the court is still here. The victims occupy the property without credit and proper document and this also the defendant is owner of the property. So there is no necessity to bring other documents for anything. In such position, I have to believe that defendants are entitled to get a degree as paid for on the basis of property. Why not? I have to fix for tomorrow. Fix for tomorrow, sir. I don't have that much idea.
Yes, I am not arguing. You not argue. You will come tomorrow, na?
No, Your Lordship, one thing is to be seen that the agreement, oral agreement 1980, and the power of attorney, just one thing I just wanted to show.
In the contract claim, what what is the stand taken by them?
We have,
Illegal occupy?
now permissive possession. Because all along they have said that we have permitted it. So Goda Roy has said that we have permitted it to reside in the prison.
Okay.
I just specifically look at that part of the statement. Paragraph 1B, page number 12. Good gesture. That after the unfortunate and premature death of husband of Srimati Sandhya Roy, said that the sister of the husband of the defendant was permitted purely as a gesture of goodwill and humanity and also gratuitously to occupy a small portion of land along with her temporary houses constructed by the husband of the defendant.
So this is filing written statement after receipt. You received, you have sent the notice.
Yes.
No reply.
No reply.
And before the Tehsildar also, this is not the stand taken by them.
No.
They want the possession from him,
Yes.
from you.
Now, this permissive possession aspect also has not been proved.
Correct. That's I'm telling,
Yes.
because their case, after the death of Nityananda, you have applied before the Tehsildar, they have admitted with regard to your possession and taken time because of the pendency of the suit. Correct. And in the suit, before the Tehsildar, they will say that they will execute. They have not taken this stand, then now they have given the permissive possession, we will not execute, he may be evicted. And subsequently, then the Tehsildar dispose of the matter, then you send a notice. In the notice also, they have not given any reply to that. No defense has been taken. Now in the written statement, they have taken this defense. And in the defense, but there is no evidence on that.
There is no evidence on that. And more specifically,
Because the defendant number DW2 also stated that he has been kept as a friend or whatever it is.
yes.
Defendant number 2, what he stated? Defendant number 3.
Paragraph 5 of the chief estate.
DW2.
DW. Friendly terms. But here it is changed. There Sandhya has allowed it.
That's simple.
Here Nityananda has allowed.
That's he has stated Sandhya.
Sandhya.
Yes. Next.
Now you should the law position and the
Come tomorrow.
here.
Tell your senior, come tomorrow. Ready. Huh? No. At the Leonard Council for the appealant at length, but due to paucity of time, hearing could not be completed. Fix the matter tomorrow as parted at the top under the heading hearing.